run through the
Okay, so the first thing the agenda is, who are you dealing with? That is maybe clearer when you're doing what Joe does, defending people against government. It may not be clear on who the actual individuals are, but who the entity is when you're doing agency work. Sometimes even the FDA is divided up so many different ways, if it's tobacco, if it's food, if it's medical device, and you need to be clear about that. So we'll talk about that. What kind of legal proceeding is it? Preparing the company, which is maybe should be first on the agenda, but we'll talk about that because if you're prepared, you do better. And then what does winning look like? Go ahead.
Great. Just advance. So part of understanding what problems look like and how to avoid them or how to deal with them is to understand sort of who you're facing. And that can look a lot of different ways, as we all know. Obviously, our focus is the FDA, the federal agency. But related to that is the Department of Justice, which can get involved and really increase the stakes. Frankly, in my world and in healthcare in general and companies in general, whistleblowers and relators and key TAM actions is becoming more and more significant. We'll talk a little bit about that. And then there are state agencies. And I don't know if you all have been paying attention, but when it comes to federal agencies, I think it's fair to say that we are in a time of change and a time of uncertainty. And I don't know that anybody, frankly, knows how it's going to look like 6 months, 12 months from now, but we all know it's going to look different. I think we have come off of 4 years of really quite active federal agency engagement, really almost across the spectrum, both in terms of antitrust, in consumer fraud, in sort of the financial space, and in the healthcare space, very, very active federal government, federal agencies, OIG, FDA. While the noise in Washington, at least currently, and we're, a month into a new administration, seems to be focused more on financial regulation and tech regulation, which does overlap with some of our medical devices, obviously. And I think it's probably fair to surmise that federal agencies are going to be less engaged. They may even have fewer employees. I think there's an expectation in the business community that the justice system or federal agencies, it's a math problem. And if you have this issue, you're going to get this outcome. Whereas the reality is that you're always, whether you're dealing with the Department of Justice or federal agencies or whistleblowers, you're always dealing with human beings on the other side. And if those human beings have family issues going on, it affects how they deal with your case. If their job is under threat, it is going to affect how they deal with their workload. So these kinds of issues will impact just sort of the bandwidth of these agencies. And I think it's fair to predict that in the short term, at least, and maybe even the longer term, in some spaces, there's going to be less federal agency regulation. The healthcare space, though, I don't see a whole lot of indication so far that is going to look any different in the near term. And I'm not sure that we can assume in the healthcare space, whether we're talking the FDA, CMS, OIG, that those federal agencies are going to operate differently. In some ways, one of the strongest proponents of federal agency action in the context of healthcare has been Chuck Grassley, a Republican senator from Iowa. In terms of, and if you look at the federal budget and you look at where the dollars go, you know that a lot of the dollars are going to healthcare. And one of the tools that the federal government has to deal with either trying to slow that down or claw that back is federal agency action. So I think in the healthcare space, it's going to be business as usual, or at least that's sort of I think the bet right now. I don't know what, Dave, if you have got a different view on that.
I'll come to that. And first, I want to say on the state agency part, I think you'll see consortiums of states more active in enforcement. They're suing the government now over getting their money from whatever Congress allocated for them first, but eventually they might decide that if somebody's not going to deal with some problem with some therapy or some other device or whatever it might be, they'll just do it and not wait. And they all have, not all, but well, maybe all have fraud cases or consumer protection laws, or I mean, anti-fraud statutes and consumer protection statutes and all the tools they probably need to prosecute cases that the government might otherwise. So that might increase where in the absence of federal engagement. And I forgot your question, Joe.
No, but that's all right. I mean, it was first focusing on where you think federal agency action is likely to go. But I think your point is a good one, which is even if you have a subsidence in federal agency action or engagement, states, whether you're talking California or Minnesota, are going to increase that engagement. It will look slightly different, but maybe not all that different. And frankly, you know, we have clients who are actively dealing with state agencies, and state agencies regularly have the ability to put businesses out of business, you know, sort of the business death penalty of sorts, in a state. And that's been true in the pharmaceutical area, where I had a client where they were going to lose their license to sell their pharmaceuticals. I know we've got healthcare clients now that are dealing with suspension of payments if you're reliant on state funds, Medicaid funds, or for payment. We're dealing with sort of a decision by a state agency that they just don't like how you do business, or they think that there's something wrong with it. And it's important because there's very little process. There's very little ability to engage in appeal once they've come to that conclusion. Now, lawyers right now are fighting about whether there's sort of an ability to engage in sort of a judicial review of that. But typically, and this is why it matters when you're dealing with a federal agency, whether it's FDA or the Minnesota Department of Human Services, their initial conclusion about what's going on can have devastating effects and not a lot of recourse for businesses. And so handling those agencies carefully is important, because your ability to litigate is limited. Right.
I'm going to say one other thing I don't know, or how it might change, and that is referral of cases from FDA to justice. I don't know if that, for me to sit here and say that I knew why all those got referred or not referred would be not truthful, because it's amazing what choices are made. I'm not being critical of their intellectual support or legal support. It's just, you don't know sometimes what the politics are involved or why something gets referred to justice. So we'll have to see what happens there.
And it's hard to predict, because I think there is a level of, I mean, it does ultimately go back to who are you dealing with, and frankly, knowing the person and how they operate, because typically agents, or, you know, have sort of a game plan that they follow, and knowing that game plan helps you do that. I think we should touch briefly on relators and whistleblowers, because that is becoming very prominent, both at the federal level and at the state level. Frederickson helped a large device company deal with a relator TTAM case in California, where the theory of the case was that the company lied to the FDA to to induce it to approve the product, the device, and it was not a great case. The allegations were not great. The theories of damages were not great, and the company spent years going up and down to the Court of Appeals in the Ninth Circuit, and then doing discovery on the case, millions and millions of dollars dealing with relator qui tam cases. And the thing that has been changing over the years in qui tam cases is historically, the qui tam statute was set up during the Civil War, 1864, for basically producers that were selling sawdust to the federal government instead of gunpowder. And it was an effort to recover the funds. It has evolved, though, to it's not just recover the funds that the federal government improperly paid or paid for poor product. It is now treble damages plus penalties plus potential exclusion from a federal program. And if you're reliant in any way, or if your customers are reliant on federal dollars, Medicare, Medicaid, it is effectively putting you out of business to be found liable, making it very difficult to litigate. And what has happened over time, because the private party who has brought the lawsuit gets a cut of whatever the government gets, they're incentivized through sort of a percentage, which can range from 15 to 25%. Over the last 10, 15 years, whereas historically relators would bring a case, turn it over to the Department of Justice to investigate and to pursue, or decline, and the relator would just sort of walk away. What we're seeing more and more now is whistleblowers bringing the case, turning it over to the Department of Justice. The Department of Justice looks at the case, declines to take the case up, to pick it up and pursue it on behalf of the United States. And the relator continues to pursue the case on behalf of the United States. And so you've got a private litigant deciding that you as a company have to spend money to defend yourself, to do discovery, to produce documents, all because they claim that you're doing something wrong. And to add complexity to it, then you've got funding organizations that are now funding relators. So you have sort of financial people who are getting involved in basically buying the claim from the relator, funding the litigation, with the hope of a large recovery against a large pocketed organization. Makes it very, very challenging these days and costly. And while the Department of Justice theoretically and ostensibly is supposed to oversee those cases brought by the third parties, in practice, it rarely happens that the Department of Justice will ever intervene and dismiss a case, even if they don't believe in the case. So you're left dealing with, not only do you have to deal with the Department of Justice or the FDA in terms of what they think you're doing right or wrong. Now you have to deal with anybody who thinks that you're doing something wrong. And it used to be sort of inside employees or employees who thought that you were doing something wrong and wanted to whistleblow. Now we have cases involving competitors who have heard rumors that there's something going on that they don't think is right. Or even now in the context of the PPP loans, and that's a little far field from this morning, people that just do internet research to find out who got a PPP loan and decide whether you are eligible or not. And all sorts of entities are dealing with those cases right now. So this is an area, you're no longer just dealing with the government, you're dealing with people acting with a badge, what I like to call sort of privateers that we've sort of legally deputized to go chase money or at least claims of money. And David, I know you have been on the other side of that and probably have a slightly different perspective than I do.
Yeah, so twice, and one the government intervened and one They did not. Well, they always intervene at the end if you're successful, right? They're not going to let their share be lost, and they want to help you define what the damages are when you get close enough or you're on the precipice of a settlement. But yeah, it's those aren't going away, and they may come to other industries, including food. I'm surprised we don't get more bounty hunter cases when there's big outbreaks like the Boar's Head and things like that. I just don't, maybe you haven't caught on yet, or maybe the money's not there. Maybe they don't have government contracts is probably the answer to that.
Well, we're just seeing plaintiff firms get
Yeah.
more and more into this as they see the money that's available. And not only are you, what's interesting, if you settle the case or if you lose the case, you're not only liable treble damages, civil penalties to the government, you actually have to pay the attorney's fees for the relator. And so even if you come to a resolution at the end of the case with like negotiating with the government as to what the right number is, and it's never the right number, then you, on top of that, you have attorney's fees, which can frankly outbalance in some instances the rest of the case.
It always makes the relator mad.
Yeah.
That you got paid.
Usually
maybe more than
it's almost all.
Well, you spend 5-6 years on it, right?
Right. The relator does almost nothing in
Right.
the case. Fair enough.
So what kind of legal proceeding is it? I'm just going to start here to say that when you're doing agency appeals or challenges, you need to be aware of the Administrative Procedures Act and know what kind of rules, or are they even rules, or are they even statutes, what you're dealing with in terms of how the Administrative Procedures Act will play into the path you have to take to appeal, right? Usually you can find out by calling or something, but sometimes it's not so clear depending on what you're doing, and whether you have access to federal court or not, or you have to go through an ALJ. And sometimes there's very specific procedures depending on what kind of procedure it is, what kind of device it is, and whether it's civil monetary penalties or things like that. So the first two bullet points sort of go together in what I do mostly or have done over the last 10 years. And so you need to be aware and be ready for changes in procedures. So the new administration can, and it happens with new administrations, they just change how you appeal agency decisions. And you need to know what those are.
And sometimes they deny the rules that they've previously established and don't like anymore.
Right. And you gotta be timely. So they don't change that usually.
So typically, you start any investigation with, whether it's in the context of Department of Justice with a civil CID, civil investigative demand, a subpoena. In the FDA, they have all sorts of investigating tools. And during that period of investigation, you are subject to all sorts of requests, demands, inspection rights, interviews, depositions, substantial costs. Now, there can be some negotiation. I think that sometimes people start with the proposition, well, if they ask for it, I have to do exactly what they say. And usually there's room for negotiation based on what's reasonable. I will say, from being on the other side of the table, the problem that investigators have, whether they're the Department of Justice or anywhere else, I don't know what the inside of the company looks like. I don't know what kind of documents you have. I don't know what kind of, who does what. So it's a bit of a black box for the government in terms of how to investigate you. So what they do is ask for everything essentially, and where people like us can help is trying to explain to them what they really want to look at, and let's narrow down and try to get at the low hanging fruit and what you really need to sort of investigate whatever it is that you're investigating. And there's horse trading back and forth, but that's a delicate process because they have a significant cudgel. Ultimately, they can go to court to enforce the subpoena. depending on how egregious they're being. Judges typically are going to back them up, typically, unless it is sort of obvious that they're not being reasonable. But that is sort of the start of the process. And frankly, given the, whether you're talking the FDA, shutting down a manufacturing site, for example, or a state licensing, shutting down your license, given the potential ramifications, typically you never want to litigate. I mean, I'm a litigator and I'm going to tell most of my clients, you don't want to litigate if you don't have to. If you have viable options, it's expensive, it's uncertain, the outcomes are not great. You should avoid litigation whenever possible. Sometimes it's not possible because the government isn't giving you any great options. But dealing in this process, these proceedings and these investigations, and we're going to talk about what winning looks like in a second, but your ability to litigate, when I was a prosecutor, I had a friend who worked at a very, very large pharmaceutical company. And he was whining to me one day, or I thought it was whining, about how in False Claims Act cases, really companies don't have the ability to litigate, so that the government has a theory of facts and a theory of law. The company may have a very different view of those facts and those law and the law. And unless you're willing to litigate that in a court with a judge, it's what they say is the law. And for the most part, you don't want to litigate unless you have to. And so that's sort of the problem, is that they can look at a set of emails and selectively pick the ones that sort of support their notion of what's going on, and their theory of the law, which may not even be accurate, and impose on companies an outcome that may or may not be just. And the ability of the company to fight back is really quite limited. And now, if you take the relator example, now you're talking about somebody that, with government personnel, employees, Department of Justice, they get nothing out of this, right? They think they're doing the right thing. They try to do the right thing. They may or may not be all that successful at doing the right thing, but they're not getting compensated for whatever they're doing. With the relator actions and the whistleblower actions, they are being compensated for what they're doing. They have an incentive to stretch and shift the truth, and it creates all sorts of different impediments in how we're doing healthcare right now, at least that I'm seeing.
One more, I think it's amazing. You get into these and you think of things, right? So you need to find out, if you get a CID, for example, you need to find out if you're a target or a witness or what you are. So I've had clients get civil investigative demands, and one was the testing company for, this is public now, so I can talk about it, and it's over, for Blue Bell ice cream. So this is 8 years ago, whenever, and they had people dying from, they're still heroes in Texas. But anyway, so, it was hard to know as the testing company what your position is, right? So when you get this request for information and interviews and we're going through, you're trying to decide if you're ever going to become a target or not. I didn't, because you are doing this, you're kind of at the whim of the company and what they do with your results, right? So if you're getting presumptive positives and you're telling them, look, you got to retest these things when they come up with that result. So, constant dialogue with investigators is important, because we kind of wanted to make sure at some point we're cooperating, give them the information, right? I mean, that's not the question, but there's a difference between somebody providing information and somebody being a target.
Well, and you bring up a very good point in terms of how you participate in an investigation. I mean, you have to turn over documents, you have to do interviews, but you do not have to explain things to them. You do not have to shed light on them. Now, I've had many clients that think it's in their best interest to shed light on something, to try to help the government understand their business, why they did what they did, how it complies with what they did. But there's pros and cons to that, right? Because you can do all that, and if you don't have confidence that they're seeing things in a fair and objective way, then you are giving them sort of a roadmap as to how things work, as opposed to leaving them in the dark and letting them try to figure out what it is. So there's a risk reward in terms of shedding light on your business, which is completely voluntary, right? You don't have to do any of that under the law. You're just required to turn over documents and sit for depositions maybe and let them ask whatever questions they want and tell them nothing. But you're leaving them in the dark, and they may or may not figure things out.
Right. All right.
If you're very confident that you know what you're doing and that it's right, then it behooves you usually to tell them what happened.
You
If
can
you're
be
less confident, maybe not.
We were confident in what we were doing as testing experts, but there's so many tests done over the course of 3 or 4 or 5 years. I mean, it's the amount of information is overwhelming, and you don't know if they're going to have some expert look at that and go, well, they should have changed the testing. There was new technology beginning in this year and they didn't change that. And, if you're suddenly going to get swept up in it, even though it was clear that the company that we were doing the testing for was ignoring the results.
Well,
And luckily we had the documents to say, hey, we were waving our hands, right? But
that's a good point, because, you like to make decisions based on perfect information.
Right.
If you know that what you've done is right, all the facts, the law, it makes the decision to, provide clarity easier.
mm-hmm.
It is a rare thing that I have perfect visibility into all facts,
Sure.
and even rarer when I have perfect visibility into all law. And so inevitably, we're advising clients, and clients are making decisions on imperfect information, even about their own company. I mean, I love it when the federal government tells me, well, why don't you just, tell me what the company did? And I'm like, well, we have 250,000 employees. That's really easy for you to say, and a much harder thing for me to do. Frankly, if I have an individual client, I don't always know what they've done. And there's a fundamental, typically, misunderstanding of the federal government by people in the federal government of how companies work and how the complexity of business and the complexity of the organization really impedes your ability to know exactly what has happened on any given business. And so part of our job is to help, a government lawyer understand, hey, if I ask the federal government for, a simple question, it will, the government would take 5 years and 50 people to tell me, an answer that isn't even an answer. I'm going to do a little better than that, but it's going to take some time, because I don't talk to one person, I talk to 20 people, because this person doesn't know the answer, but they know somebody who might know the answer, and then that person can put me. And this takes time in the context of a investigation, and managing expectations about how quickly things can be turned over, because you're dealing with the government typically with a suspicious group of people, a group of people that think, at least many of them think, that for-profit companies are bad, and that is a motive to commit fraud. I try to explain to them that in the United States of America, we've decided to have a for-profit healthcare system that only kind of helps, but they're dealing with a very different mindset than what we all deal with. And I think it's important to understand that mindset.
And they have no idea what the end is. They don't know when they're done.
No.
Right? Unless you tell them. And then you have to balance the things. Oh, we got to get going here to preparing the company, and then what's winning.
Well, Sarah and I had to deal with Congress one time, and with Congress, all you hope is that they see another, dog with a fluffy tail and go chase that, because that's the best you're going to do.
The first thing I did as a lawyer was involved the Shiley heart valve. It was a just an associate in a sea of documents before technology. And it got before Congress. I didn't go before Congress, but I got a window into that. That's a different presentation because there's no privilege, there's no confidentiality. I mean, there is, but it
Yeah.
gets wild. Anyway,
Yeah. They don't think there's privilege.
so preparing the company, I can't emphasize this enough that while it's hard, especially if it's criminal, to have people ready for investigations and CIDs and certainly inspections, but most companies are prepared to do, well, it depends on their size, but larger, sophisticated medical device and drug companies for sure. But you need some education even in the C-suite and other places by in-house lawyers or others about what preparation well, first of all, what the process looks like, and then what preparation might look like is very important and makes things a lot easier when they come knocking.
That's exactly right. I think, there's sort of two or three things that I would, documentation is always difficult because it seems kind of like a waste of time. We know what we did, so why do we need to document it? The problem is investigations are always, 3 years, 5 years later, and, the people who did whatever it is we did are gone, and maybe even their successor is gone. And so it's hard to recreate what has happened. And in well, I shouldn't say every case, but in many cases, lack of documentation hurts the company in terms of defending itself. And good documentation, whether it's your policies, whether it's your procedures, whether it's a demonstration of what you did and why you did it, is if you can explain why you did what you did and that it was reasonable in the context of what you were doing, that's a good defense typically to most issues. The other thing that I've seen in dealing with the government is, they love emails. I was a prosecutor. I loved emails. I guess text messages are now more the same. And our business people are not always focused on, they're usually very focused on sales and revenue, totally understandable. And there's nothing illegal about that. There's nothing wrong with that. It's necessary to, the for-profit model that we have in America. What we need to do is balance that in our communications, our email communications, of revenue and compliance, and making sure that the tone from our leaders and our managers and even our middle managers is balanced. There's nothing wrong with holding people accountable to their sales targets, but making sure that they understand that sales has to be coupled with compliance is, important. And, the government lawyers or the relator lawyers or the agency lawyers, when they see an email that is unbalanced and focuses solely on revenue and profit, they start to see red lights, and it makes your job defending the company more difficult because there's an imbalance in the email, and then there's an imbalance in that government attorney's mind, which may be entirely unfair, but that's how they're used. Those, there's a selective process. I've got a theory that they're cutting short on compliance, cutting short on inspections, cutting short on audits, and it's causing problems. And here's this email that supports that notion. So I think that's good. We should turn to.
I'm going to say one more thing about this. If somebody sends you an email identifying a problem, answer say, I got your email. I understand your concern, or if I don't understand it, let's get together and talk about it, and then document the resolution. I never forget going as a young associate, telling the guy who was going to try the case all the problems. He goes, well, what's our story? Well, then you got to go back, right? Because you're so focused on identifying the problems. But the companies have good stories to tell. They probably did address a whistleblower's problem. Well, maybe or maybe not. Well, but sometimes they have. And so when you document things, when issues come up, and they probably come up a lot, make sure you document the resolution.
Well, and I guess I would also discourage people from using hyperbole or
yeah, absolutely.
or conclusions, factual conclusions that may not be based in truth. I always remember the CMS official following healthcare.gov who had the email talking about how we don't want healthcare.gov to crash on takeoff. And he got called in front of, Congress to testify about his email about crashing on takeoff. That was just not a pleasant day for him. And I sometimes would show a picture of him testifying in front of Congress to show to our business leaders, imagine being in a deposition where you have to explain your emails. Got to use email, got to communicate. I understand that. But the words that you use, you may have to explain someday in a less than pleasant circumstance. But we should talk about what winning looks like, because winning doesn't look like winning. It looks like not losing a lot. That's it looks like
protecting the company, keep doing business, keep having government
losing
contracts.
as little as possible.
Right.
The justice system, the litigation system, none of it is really set up to deliver fairness, and it is costly. It is painful. It is distracting from the business. And so getting through things as quickly as possible, and moving on and getting back to the business that you're all in is the only goal. And so people can spend a lot of time getting caught up in fighting things that they think are unfair. And when the government is being unfair, which it is, that is a costly and painful principle to try to fight for, and usually ends poorly. And so if we can reset expectations and just try to keep the issues narrow, don't expand more than we have to, so keep the issues narrow and move through it as quickly as possible. I think that's the reasonable expectation and goal for companies dealing with these kinds of issues.
What are the issues that you're resolving? And who with whom, right? So if False Claims Act case, does the state have an interest? Do they know about this? Are they going to bring a claim? They're probably not going to get them to the table, but you might. What does OIG say? Even though you're settling with the relator, so they might have a say in it. So get as many parties do you think are relevant involved in the settlement as you can. And then what's the compliance going forward? Do you have a set of expectations and requirements for compliance that are different than the normal ones that you've been acting under as a result of the settlement, and for how long, and things maybe you've all been through, but an important checklist, I think.
I know we invited questions at the beginning. It's early, but we're getting, coffee is settling in. I'm wondering if there are any questions, but I know that we're about to time here. Anything? Okay. Thank you very much.
Sorry, there's one online question that I'll read off.
Yeah, please do. I'm sorry.
How
It's
will
too small.
potential administration changes impact the role of the FDA ombudsman in the legal process?
Boy, if they have one, I don't know. I think what's going to happen if I can only predict on what I think the principles are of this administration. So a war story. I've represented clients, especially in food, where if they have to comply with new changes that are loosely connected to the statute and the rules, right? So their interpretation, I think, is outside what the rule actually says. I think there's going to be less enforcement, especially against smaller companies, right? That might be actually a good result. So that's all I have to say about that.
Yeah, I can't speak to the FDA ombuds person other than just sort of the general uncertainty in DC. Although, you don't hear a lot about CMS and FDA at this point. At least I haven't. Right. I think what we are moving towards in a bigger picture, and this predates this administration, is less we hear a lot about Chevron and sort of the reliant, the court's deference to administrative bodies. That is going to continue to shift away from sort of reliance on administrative bodies, giving people a little bit better leg up and maybe the possibility of going to court.
Depends what jurisdiction you're in.
Right, it depends a little bit what's going on. I think that trend is going to continue, but again, that's a long and painful process. So-
I've never found that the ombudsman useful, so I guess I'm maybe the wrong person to comment on it.
Yeah,
Go ahead.
So why don't you just explain a little from why key TAM actions, how they work internally within the U.S. Attorney's Office, how it's so important that they raise the stakes won't normally see. What happens if the attorney in the civil division gets a key TAM action?
So a relator files their complaint under seal. So the defendant doesn't even know it exists and serves it on the United Department of Justice, both in DC and at the local district office. And DC and the local U.S. Attorney's Office figures out who's going to deal with it, or if they're both going to deal with it. Ostensibly, DC supervises, although that can look like almost nothing. And I think it's 90 days that they have to investigate it originally. And they're supposed to make a decision whether the Department of Justice on behalf of the United States is going to intervene and take over the case and pursue it for the United States and bring all of their litigation resources to bear, which is not insignificant. And inevitably, that 90 days gets extended, sometimes for years, sometimes for 5, 6, 7 years.
Who gets assigned investigating? Not the individual lawyer. What does the lawyer actually do when it comes in?
Yeah.
Does he call or she call up?
The
Typically,
relator lawyer.
it calls the relator lawyer for an interview, and here's what they got on the inside, and then talks to typically an OIG agent, HHS OIG, but sometimes FBI as well.
So in other words, the case moves into, it gets assigned to be actually investigated by the federal government because a lawsuit was filed.
Correct.
So there's not, the case gets to the criminal people actually oftentimes before anybody knows whether or not they're.
Well, it goes to the civil folks first. Now, Daniel, what you're talking about is how it gets referred to the criminal folks. And there is communication, and there's supposed to be communication between the civil division and the criminal division. Criminal division takes some of those cases, in which case sometimes there are subpoenas and search warrants and interviews. That does happen from time to time. And so as a company, sometimes you think you're dealing with a criminal case, but it was really started as a key TAM civil case, but has evolved into a criminal case. Oftentimes those criminal cases don't go very far, and it reverts to, the good news is you're done dealing with a criminal investigation. The bad news is you're dealing with a civil case, and I don't know if it's better to deal with the Department of Justice or a relator. Usually companies used to cheer when the Department of Justice declined to intervene, but relators have become more and more problematic in terms of how they're financed better, they're lawyered more, there's more of an investment because there's potentially a big return on the other side. And so the plaintiff lawyers, historically, plaintiff lawyer looking things have decided to get into the False Claims Act. And if you go on plaintiff lawyer websites, you see more and more of them with, False Claims Act, whistleblower complaints in there, sort of inviting plaintiffs, employees, competitors, random third parties to bring a lawsuit against any company. And the key though, it's always about government money. So if you don't have a program looking at government money or getting government money directly or indirectly, it's not going to be a key TAM case.
So when I had they were providers in both cases, doctors, and I was the investigating person. So I worked with the assistant U.S. attorney here, and he and I did all of it. I don't recall any assistance from anywhere else. Matter of fact, I kept asking them, get some Medicare people help us out here. Depending on the case, right? So if
Depends
it's
on
a
the
giant case and it originates in some particular district and it high profile, these are millions of dollars, but not like some. And so the resources can vary within wherever you're working. So
Great. Thank you.
thank
Thanks,
you.
Dan.